from all of us to Leah for organizing this event. My name is Asser Hansen. I'm from MERGERFILERS, and I just have a few opening remarks. For those of you who don't know MERGERFILERS, it's an international guide on merger control and the decision database as well, free to use, and we are supported by over 50 top law firms around the world. So the topic that we're going to discuss, or the panel is going to discuss, is Article 22 referrals and the Towercast judgment and the consequences of this. So when I first learned about competition law, I was told that merger filing thresholds, they are sort of a compromise between, on the one hand, legal certainty for businesses, and the other hand, the need for authorities to review the most significant transactions. So the idea was simple, that you had some very objective thresholds, that if you were below those thresholds, then you're safe. You could go ahead with your transactions and wouldn't have to worry about deadlines or the costs or anything else. So over time, authorities have had concerns about transactions that were not caught by the thresholds, killer transactions and other transactions below thresholds, and how to tackle that. So was it time to introduce new tools or review thresholds? That was sort of the question. Maybe, as we heard yesterday about market share thresholds in Portugal and Spain, maybe that was something you could consider. But actually, it turned out that we didn't need any new tools. The tools were already in the toolbox. And the legal certainty that I was once told that businesses had probably never existed. So our three speakers in the panel, they're going to discuss, well, do the authorities now have the appropriate tools, and how to deal with the increased legal uncertainty and red tape from the Towercast decision and Article 22 referrals. So to set the scene, we have in the middle Björn Herbers from CMS in Brussels. He's a partner at CMS and has extensive experience in merger filings for the Commission as well as on national level. Furthest on your right, we have Francisca Solarillo, who's a policy expert and also a former case handler at the Commission. She also has experience from an international law firm before that. And to my left here, we have Johanna Lennart, who's a senior lawyer at AP Møller Mærsk, and she has extensive experience from merger filings on a global scale. So without further ado, Björn, please take it away.
Thank you, Asser. So as Asser rightly said, I'm a competition lawyer, and as a competition lawyer, life was easy when you were asked to conduct a merger control analysis some years ago. You simply requested turnover information from the parties, and you put it in your table, and then you had some results. In the end, you were pretty confident where to file and where not. I mean, in some jurisdictions it's a bit more exotic, but at least in Europe you had a high degree of certainty that the transaction was either notifiable or was not. As I already also mentioned, that this was based on the turnover threshold system that most jurisdictions apply. The simple idea is turnover is the proxy for the competitive relevance, also for the local nexus of a transaction. And if you're looking at the turnover, you can identify whether this transaction should go through merger control or not. As I also mentioned that there has been a quite lively debate now for some years whether this is sufficient to catch all transactions which should undergo merger control. So the perceived problem was that if you're only looking at turnover, you are not controlling transactions involving companies which already have a competitive relevance, but because they are not yet achieving sufficient turnover, will not trigger filing obligations. So this different jurisdictions have taken different approaches to tackle these problems. Some jurisdictions have addressed the problem by introducing transaction value thresholds. So basically the idea, if you are paying a lot of money for a company, then there must be some competitive relevance, and it might make sense to take a look at it under merger control rules. The Commission has taken a different approach. That's the, as I just mentioned, Article 22. So the precise wording was a recalibration of the Article 22 EU merger regulation policy. A quick look on Article 22. If you don't have it in mind, that's the referral to the Commission. Under this provision, one or more member states may request the Commission to examine any concentration as defined in the merger regulation if it affects trade between member states and threatens to significantly affect competition within the territory of the member states requesting the referral. It's called or referred to as the Dutch clause, because at that time when the EU merger regulation came into force, the Netherlands didn't have merger control rules, so it helped countries like the Netherlands to refer cases they wanted to have checked to the Commission. Nevertheless, I mean, in the meantime, most EU member states have merger control, so the more or less common understanding was that a member state should be competent under its own merger control rules in the first place if it wanted to refer a transaction to the Commission. And the Commission has changed this policy in 2021. There was a communication, and I'm sure Franziska will shed some light on this in a moment. And under this new policy, member states may now also refer transactions for which they are not competent themselves to the Commission, meaning basically your certainty from looking at turnover thresholds or turnover tables or also transaction values is gone, because basically if the Commission, with a little help of its friends at the national competition authorities, can basically pick up any case they consider worthy for review. Before I let Franziska defend this great new policy, just a quick look on the decisional practice has happened since 2021. So shortly after this policy was published, I think it was just 1 week, there was the first referral to the Commission under this new policy. The famous Illumina Gray case, also famous for different other aspects, because Illumina was really fighting the Commission on this case. They caught a gun jumping fine, and so very interesting case overall. So this case was referred to the Commission. The Commission accepted the referral. Illumina challenged the acceptance decision, and the acceptance decision was confirmed as lawful by the General Court already last year. Now the appeal is pending in front of the ECJ. And just last month we had 2 new Article 22 referrals. Both have been accepted by the Commission. This is Qualcomm Autotalks and then EX NASDAQ, so energy directives. So Franziska, some ideas on what are we looking here with the Article 22?
Hello Thank you very much for the introduction and the invitation for being here in this theater. It's an interesting venue to have a conference. I'm speaking, of course, in my personal capacity. So I was invited to give you a bit of background to the Article 22. I think I will start with how it was developed. So in 2021 and before, the Commission assessed in an evaluation whether our turnover-based thresholds are still fit for purpose. And this evaluation has shown that actually a number of transactions that could potentially harm competition within the internal market were not caught by the EU merger thresholds and therefore escaped merger control at EU level. And this concern was concerned particularly a specific case of categories. So it was notably acquisitions involving at least one company with low or no turnover, but with a significant competitive potential. This issue has been partially mitigated by referrals from EU member states, but there were certain transactions that have been neither reviewed at national level nor at the EU level. And this includes, in particular, some acquisition of nascent competitors and very innovative companies. That then led to the Commission to issue a guidance document. It was published in March 2021. There it announced that it would no longer discourage, but actually accept, in certain circumstances, referrals under Article 22, where the concentration does not meet the national filing thresholds in the member states. So in the Commission's view, this revised approach to Article 22 is a targeted and proportionate tool because it gives the Member States and the Commission the flexibility to target those type of transactions that merit review without creating additional red tape by introducing, for example, other mechanisms like a value-based threshold that would also catch transactions that may not merit the review, and therefore creating a lot of administrative burden both for the companies and the Commission. And the experience so far confirms that this revised approach to Article 22 as an exceptional safety net, this is how we see it, really ensures in a practical way both this equilibrium between the effectiveness of merger control, that we need to look at transactions of innovative companies that do not yet have turnover, but also is a proportionate tool. We see this also now with the two most recent referrals that Björn mentioned. So that, when you look at the cases, I think there's a broad consensus that at least on a prima facie assessment, this is what we're doing in Article 22. Those cases should be looked at, even though they were not caught by any national thresholds. And for example, in Qualcomm Alto talks, 15 member states ended up referring the case to the European Commission. So there's a broad acceptance also between the member states of referring cases. EES NASDAQs had more Nordic focus, and there was 4 Nordic countries who referred the case to the Commission.
So these are 3 cases. I've heard that the Commission has actually looked at also a couple of other cases, and in the end decided not to pick them up. Of course, you can't mention exact cases, but what are the criteria, or how does the Commission identify suitable Article 22 cases? Are you screening you don't have notifications, but you have publications, announcements? How do you become aware of Article 22 candidates?
Yeah, so there's various ways. One possibility to become aware of the transaction is if merging parties reach out with a briefing paper. Then there's also third-party complaints that competitors or customers reach out alerting us of a transaction that they think merit review. Then there's also other competition authorities, either within the EU or outside the EU, that may suggest some transactions to be looked at. And then in parallel, we also monitor the market ourselves. So this is our ex officio monitoring. We are there basing ourselves on press, specialized press, but also databases. There's some specific databases in some industries, but also transaction databases that we look at. And then an additional source that is now coming into force was the DMA information requirement for gatekeepers to inform the Commission about certain intended transactions. And so then how we proceed is we look at this first information that we either see from publicly available sources and or from the parties or third parties, and we start our assessment. We go into the criteria in a moment, and if we think that we don't have sufficient information to do this prima facie assessment whether Article 22 kicks in or not, we sometimes then issue RFIs, information requests, to the merging parties, and so engage with them and get information from them. So I think our criteria are set out in this Article 22 guidance that we issued in March 2021. First and foremost, there are the two legal principles in Article 22 itself that Björn cited before. So we need to have an effective trade between member states, and also the transaction needs to threaten to significantly affect competition within the territory of the referring member states. So these two criteria need to be met, and then the guidance also clarifies that there are certain additional elements that the Commission may take into account when assessing whether it's a good candidate for referral. And this is the overarching principle here, is that the turnover is not reflective of the competitive potential of the company. This is our first criteria that we're looking at, and then the guidance has also a few other illustrative examples of good candidate cases, and that would be, for example, if a party is a startup or a recent entrant with a significant competitive potential, whether it's an important innovator, actual or potential important competitive force, has access to competitively significant assets, or provides products or services that are key inputs or components for other industries. So this is what is set out in the guidance, and we also issued a Q&A document in December 2020. It was uploaded. It's on the Commission's website with some more practical information as to how to engage with the Commission.
I mean, since the decision by the General Court of July 2022, so the Commission has some legal certainty that the Article 22 policy is lawful, can be put into practice. Still, we only have seen two cases, which confirms what you say, that it's as a safety net for exceptional situations. But you also just hinted at something that just entered into force. That's Article 14 of the Digital Markets Act, the DMA, which basically foresees that designated gatekeepers under the DMA, and the designation decisions that just have been taken, at least the first round, have to inform the Commission. They don't have to notify their transactions, but they have to inform the Commission about any transaction which could give them a data advantage. So pretty much every transaction. So I assume the Commission will see now a lot of notifications, because that was also one of the concerns with the traditional turnover-based thresholds, that in particular big tech would have do a lot of transactions which would stay under the radar, and a couple of years later you would say we never should have allowed this. So are we going to see a wave of Article 22 cases now, or what's the future?
So this information requirement that is in Article 14.1 of the DMA is first and foremost an transparency obligation of the DMA. But it will be another source, of course, for the Commission to identify potentially suitable candidates for referral under Article 22. the information that the gatekeepers have to provide is defined in the DMA, and there's also a form available on the Commission's website for the information to be provided. I mean, we do not have a crystal ball, of course, and it's just started. So the information obligation kicked in with the designation of the gatekeepers that have just been finalized for the first 6 gatekeepers. So we expect a significant number of these submissions under Article 14.1, but without having looked at the cases, we cannot yet foresee how many transactions might be very good candidates for referral under Article 22. But honestly, we do not expect a wave of new candidates, and we really see this Article 22 tool as an exceptional and very selective tool to review transactions.
Maybe also to Joanne, as somebody who has to live with the disclaimer now in every merger control assessment, there could be, of course, always Article 22 referral. Do you see any room for improving deal certainty or reducing this red tape? I mean, there's this guidance, but still, I mean, sending a briefing paper to the Commission for every transaction, you also already have to do this in the UK in a lot of cases. Yeah, what could be done better?
So maybe just to start with, at the beginning the impression was that Article 22 would be applicable to big pharma, big tech cases, very innovative companies. However, the guidance does not provide for this limitation, so there is no limitation to the sector, to the industry. And this, of course, creates another layer of legal uncertainty. And it simply makes deal-making more difficult. And from my perspective, representing the industry here, legal certainty is key. So how do I explain to my M&A colleagues, how do I explain it to the steering committee for a particular transaction that, well, this transaction does not require a filing, but it might. And then how to address it in the SPA practically. When actually will we be really sure that this is a deal done? So these are the challenges, definitely. I would see some possible alternatives. From our perspective, from the business perspective, there would be much more legal certainty if, for example, a threshold referring to a transaction value was introduced, because then, as Björn mentioned, it would be a very similar exercise to the one with the turnover figures. Then another one could be providing specific thresholds, maybe lower thresholds for certain industries where these concerns are identified, as it is the case in some national competition law regimes, for example, when it comes to the media sector or financial sector. I, of course, understand that the Commission wants to make sure and wants to capture a broad range of cases in all industries. However, it makes deal-making definitely much more difficult from our perspective. Another challenge to deal with.
I don't know, do you want to comment on this, or should we look at another problem?
No, I think that's fair. I think as mentioned, I think we looked at different ways. I mean, I think that everyone sees this potential enforcement gap if you only look at turnover, and we did look at different matrices, and for example, this value-based threshold or so on, you would, depending on, it's always, in a way, it's the value in proportion to the turnover. So but that is a difficult, it's a very difficult threshold. Also, I think what is the value of the deal is not super straightforward to identify. I mean, the Germans and the Austrians probably can tell you a bit about that. I mean, there's also a long guidance paper as to how to deal with this value-based threshold. So I think, and also it would lead to a lot of notifications of deals that are in the end not the ones that we're interested in. So yeah, there was the compromise in this evaluation reached at to go for Article 22. I must say, yeah, in order to improve deal certainty, I mean, we do encourage companies to come forward with a short briefing paper, and we say in the guidance also that we provide an early indication, so there's some certainty there. Also, I think the numbers that clearly show that this approach has a more limited impact on deal certainty than was probably probably the business was afraid of in 2021 when there was the big outcry. So I mean, just to give you a few numbers. So in the first half of 2023, we seriously considered around 20 cases, and in 2021 and 2022 together, we seriously considered around 40 cases. And out of all of those, we have 3 cases. So this also, I think, gives a bit of a reply in relation to deal certainty.
Now you can wonder whether your case was one of the cases which was seriously considered by the Commission. Yeah. So Asa mentioned a second development in the beginning, adding to Jan's worries, maybe, I don't know. And this is Towercast. So this is, so Article 22 is something new. Towercast is actually something very old, I would say. It comes from the dark times before we had EU merger control. And at that time, the EU competition authorities, in this case it was only, at that time it was only the Commission which was competent, applied Article 102, so the prohibition of the abuse of a dominant position to transactions which would infringe competition. So this was confirmed in Continental Can in 1973. The basic statement is if a dominant company acquires a competitor and strengthens its dominant position, this constitutes an infringement of Article 102. Now, in 1989, as you know, the EU merger regulation was introduced, and from that point in time, I think the general understanding was you have the control of changes of market structure, that's the merger regulation, and then you have control of market behavior, that's Article 101, and Article 102, and actually the Commission at that time issued a statement saying that the Commission will not normally, there was a small disclaimer, but apply Article 102 to concentrations, and the current procedure regulation, so Regulation 1/2003, does not even allow the application of Article 101 or 102 on concentrations. I mean, this is the Commission side. The open question was whether the national competition authorities which are applying 102 can still apply also 102 to mergers. And this exact question was addressed to the ECJ based on a preliminary referral question from France in the Towercast case. And the ECJ answered the question as follows. Even though the merger regulation introduces an ex-ante control for concentrations, it does not preclude an ex-post control of concentration that do not meet that threshold. So, then the court argued that a regulation like the EU merger regulation cannot prevent national authorities from applying the abuse of the prohibition of the abuse of a dominant position, because that's set out in the treaty, which has a higher rank. So this decision was taken in March 2023 in the Towercast case, and again, before I ask Joanne maybe to share her thoughts on this development, a quick look on the decisional practice since then. Also didn't take very long. I think it was a bit longer than 1 week, but still in March, the Belgian competition authority applied this new Towercast principle and opened an Article 102 investigation into a transaction which was below the Belgian merger control thresholds. This concerned the takeover of EDPnet by Proximus, the Belgian incumbent telecoms operator. So you have Article 22, and then you have, now there's always the risk that sometime later, even after the transaction is closed, a national competition authority would investigate this under Article 102. Does that make you happy?
Obviously, that further increases the level of legal uncertainty. So no, the short answer is no. From an in-house perspective, it doesn't make me happy. It makes my life more difficult. But I'm really interested to see how it's going to develop. Compared to Article 22, this one, at least on its face, looks a little bit easier to deal with because first you need to have a dominant position and the transaction needs to strengthen the dominant position. So at least from that perspective, this is more limited. However, conceptually, I struggle to see how a simple act of an M&A deal could constitute an abuse of a dominant position. In my view, there would always need to be some additional behavior that would be abusive. So this one, I really don't know how it's going to develop. We will see. We will see how the Belgian case develops, and then probably we will have some precedent that we will review closely and take some learnings from it. But this case is only, and this situation is only one additional area of legal uncertainty. And I will use it as a segue to speak a little bit more about other areas of legal uncertainty on a more global scale, from a more global perspective. So in general, there is a lot of regulation coming in currently when it comes to deal making. In other panels, you will hear about foreign direct investment regulation, foreign subsidy regulation, then it's merger control, and then within merger control you have Article 22, you have Towercast, and then there are so many layers. And then in other jurisdictions you have other challenges, like some jurisdictions take into account, for example, public interest considerations, which make it more difficult to assess the case, because this is more a political tool. As you know, one jurisdiction is South Africa. It's less predictable, I would say. Then you have voluntary filings, which in some jurisdictions recently seem to be more non-voluntary, actually turn into mandatory filings, or at least much more attention has to be given in those jurisdictions than before because of the change in the policy. Then in some jurisdictions, it is possible that the commitments are imposed without even informing the parties. So there are many layers of legal uncertainty. They are very difficult to deal with, especially on the business side, because we need to make sure, okay, this is a deal done. We may proceed, we may start integrating the company, which also takes a lot of time and it's quite complex. So I think life in general is getting much more complicated, and then of course prolonged pre-notification phases as well. So there are many areas, and I could go on and go on, but I think the conclusion is that our lives from in-house perspective are getting much more difficult.
Yeah, and just looking at these obstacles within merger control, and you're absolutely right to point out on foreign investment and foreign subsidy control is also now entering into force. But just on the, and I found it interesting, Asa, that you said in the beginning, it was there all the time. We didn't even need the new tools. They have been in the toolbox all the time. So what's the relation between Article 22 and Towercast? Because in principle, I mean, if you look at the opinion of General Advocate Cocotte, she mentioned a couple of fields, target cases, and she mentioned for such Towercast Article 102 investigation, and she mentioned internet service, pharmaceuticals, medical technology, acquisitions of emerging competitors, something which sounded very familiar. In highly concentrated markets. So exactly the situations which the Commission now wants to control through Article 22. I mean, so what's the relation? If the Commission decides, has looked at it, no, it's not a suitable Article 22 case, does this give some certainty that it's also not a suitable case for a national authority? Is there some alignment, or how do these two instruments play together? I don't know who thinks. Okay, you are responsible.
Well, I can give you my view. Then let's see. So in my view, reading the judgment, there are 2 points that are very clear. So the first one is that the court is sensitive to an enforcement gap. So it recognizes that a safety net is somehow needed for those transactions that can significantly harm competition, but that are not notifiable under the national filing thresholds. When you read the judgment, it also makes a reference to a transaction that fall below the threshold and have not been referred to the Commission pursuant to Article 22 EUMR. However, on the second point, I think the judgment makes it also very clear that the ex-ante review, so before the transaction closes, should take priority over the ex-post review under Article 102. The judgment says that the prior control of concentrations must be applied as a matter of priority. So, as in terms of legal certainty. So I think the judgment is pretty clear in those two ways. As a Commission, we would rather wish to see those transactions being referred under Article 22 of the merger regulation in the spirit that ex-ante control should take priority. But this requires, of course, that the transaction is a suitable candidate, meeting the criteria, including that it affects trade between member states. I mean, I discussed with the criteria we apply. If it's a purely national case, it will most likely not fulfill the Article 22 criteria, and therefore, then could not be referred. There's, of course, another opportunity there. So a transaction may be also subject to ex-ante control in member states. More and more member states have call-in provisions. Italy is the most recent one. Those transactions could be called in there. And the Towercast judgment addresses only explicitly the question whether and under which condition national competition authorities may apply Article 102. And therefore, I don't think we can say much more about the Commission's role in that regard.
It's a very, very complex situation. Jen, if you had 2 or 3 wishes, or maybe just one, because we're running out of time, what would be your wishes for changes of regulations or practices to make your life a bit easier again?
I will use all 3. If I had 5, I would use 5. But let me start maybe by saying that, we're all competition professionals. We have different perspectives, obviously, private practice, in-house, being at the authority. However, we cannot forget that we also have some common interests. We all want to make it workable somehow. And I think my first wish would be to have with every competition authority worldwide a platform for dialogue, to have transparency, to have ability to speak with the authority and have constructive discussions. Because, for example, if there is a case that the authority is able to impose commitments without even informing the parties, then it could very well be that these commitments will not be workable for the parties. So there is a lot of interest there, and here I would also look at the Commission and hope that the Commission would take a lead in, worldwide, also in the International Competition Network, to sort of encourage also the younger competition authorities to approach the Commission, to consult the Commission, and also in this, and to create this platform for dialogue. So that would be my first and biggest wish, because if the authority is unapproachable, then it's very difficult to make it work, and then it's also very difficult to make business. My second wish would be when competition authorities send requests for information, that they really carefully consider when they ask questions, that they only ask for information that is absolutely necessary, absolutely indispensable. And I can tell you from an in-house perspective, if we receive a question to provide certain information for the last 3 years, it's very challenging to collect that information. When I was in private practice and I was sending this RFIs, for the filings to the clients, I was wondering what is taking them so long. But now, being on the other side, I'm also myself surprised how difficult it is. But it is very difficult. So my other wish would be really for the competition authorities to consider the scope of their questionnaires, because going a couple of years back, especially when it comes to a big organization, is very challenging and requires involving many, many resources. So that would be the second one. And the third one, also speaking more globally, not speaking here about the European Commission, but competition authorities globally, would be about the thresholds for merger control filings. That this threshold should really reflect the potential effect of the transaction, so that always the target should be somehow taken into account. Because I find, especially thresholds which are combined domestic turnover thresholds, very difficult, because it's enough for the target to have €1 turnover and then you trigger the filing. However, the effect is zero. How can you have any effect on the market when you have €1 turnover? So to consider that, to really take into account the target company in drafting competition laws, in revising competition laws. I would have some more wishes, but I understand I don't have time, so I stop here.
That's already a lot of work for Franziska. So I think you're not imposing remedies on parties without asking them in advance. So, but with the RFIs, that sounded familiar.
I was thinking, I think number 1 and 3, I don't feel that we were so concerned. Maybe number 2 was going in our direction, but that's it.
But I think this was already a very nice closing remark. I don't know, Asa, can I give back to you for some short Q&As?
Yes, any questions from the audience? Any wishes from the audience? Yeah.
Thank you. Lucio D'Amario, Linklaters. I've got a question for Franziska, unsurprisingly. My question is, it's now more than 2 years that the Commission provided guidance on 22. Are there any lessons learned in the meantime, besides those coming from judicial review, of course? And if so, are you envisaging providing any additional, updated, more refined guidance in the next future on that topic? Thank you.
Yeah, thank you for the question. So the guidance is from March 21. So it's relatively recent. So yes, I think there are lessons learned in how do we organize this within the Commission. How are we getting very quick in assessing the transactions? Also, the more you see, of course, I think we became very efficient in reviewing those transactions, and there was definitely learning curves. I wouldn't exclude that there is a new guidance coming, but maybe it's a bit too short in terms of time that has passed since the March 21 guidance. I mean, then in December 22 we issued this Q&A document that provided additional guidance, so that was less than a year ago. So I do think that we will keep up on that, but there's nothing imminent coming, unfortunately.
Yeah, so I started out saying that do we have the appropriate tools now? And I wonder, it seemed like with the Article 22, you sort of looked into the toolbox and found something there that sort of you felt this fits our purpose for now. But is it sort of the right tool, or would do you see any sort of different way that you in future could have a regulation that more specifically targeted the needs that sort of started the discussion?
So the current situation is that the General Court confirmed that this is the right tool. The appeal is pending, but so I think so far so good. So that we can apply Article 22 that is already in the merger regulation.
I think actually the court said it's the only interpretation which is thinkable and legal. So.
Yeah, I had another question. So we've heard a lot about legal certainty, which is really important, obviously, for the firms to merge. Oh yeah, I'm from the Monopolies Commission, so from Germany. So my question is, legal certainty means kind of like 100%, you know, like there's a threshold. If you're below legal certainty, 100%, you can merge. When we then look later in the merger at the competitive assessment and the competition authorities say, oh, there's a 5 to 10% price increase, or the market shares are 80%, or it's a 3-2 merger. These are all also thresholds, but the authorities are always challenged on these thresholds from the parties. So when these thresholds apply through the competitive assessment, they never stand. They're pretty much crossed out of many merger regulation guidelines now. So how can you be sure if a merger goes under the threshold of notification that there wouldn't be any competitive effects or negative effects? And I've seen the 3 examples that you put on the slides between the, like 2 of them I wasn't too familiar with, but the EEX is the German energy stock market and Nasdaq is an American one. And I think one of the subsidiary companies of EEX has an abuse of dominance case going on at the Commission. It was opened 2 years ago, and I think it's still ongoing. So there must be more than the threshold that you can quickly apply when talking to your clients, surely, no?
Yeah, I think, so first I think the EX case here is about the intelligence unit of Nasdaq, so it's not the stock exchange which is part of the transaction. But in generally speaking, I think that goes into the direction what Jan mentioned, that these additional worries, and it's absolutely right. It's extremely difficult to say from the outset whether a certain transaction might raise a competitive concern under this perspective or another. And so we have the Article 22 is a bit looking at or the Article 22 guidance is looking in an abstract way, saying, okay, we are comparing the price which is paid for with the turnover, and so this is, I think, still more an abstract view. But you're absolutely right. I mean, you have several jurisdictions which now have introduced call-in clauses or additional clauses to basically say if you have to notify if there could be a competition problem, Hungary, for example. And this, of course, makes it extremely difficult to advise a client, because you're now mixing this first part of assessment of, we just looking whether it's in scope for merger control and whether there's actually a substantive potential problem. And this is getting mixed, and I think it makes advice more difficult, more challenging. And as I said, the result of our merger control screening used to be a relatively short document saying you're meeting the thresholds in the following jurisdictions. And now it's a lot of explanations, a lot of, disclaimers also, because, you just don't have the certainty in a lot of jurisdictions anymore. And that's certainly right that the European Union is not the worst instance in this respect.
And I think I would just add to that we never had, and it's not possible to have 100% legal certainty, right? There was always a certain margin. However, currently, there are so many new developments coming in that the level of legal uncertainty has significantly increased. And this is something we have to live with.
So if we don't have any other questions, I think we'd just like to give a very big thank you for the panelists, and please join me in giving them applause. Thank you. And there's a coffee break.